Hi, everyone. Good morning and welcome to our very first Representing Children training session. This is something that has been in the works for some time, and we are thrilled to have Andrea Doyle, KC, with us today. And I just want to take a moment and thank Annette for also assisting us in getting this together. It's something I'm very passionate about and hoping everyone learns something today. Andrea Doyle is a Legal Aid Alberta's Senior Advisory Counsel for Family and Immigration. She graduated from UNB Law in 1991, articled at a large Bay Street law firm, and then clerked at the Federal Court of Appeal in Ottawa. She was called to the Ontario Bar in 1994 and practiced with the law firm of Doyle, Spears and Ajax in Ontario from 1994 to 2007. After relocating to Alberta in 2007, she joined the Legal Aid Alberta's Family Law Office as staff counsel, representing children in high conflict family law matters, as well as parents in child welfare matters and all other family cases. From October 2010 to May 2019, she was the assistant senior counsel and then senior counsel of the Family Law Office, responsibility for the Edmonton office, leading, managing, and mentoring the family staff lawyers. In May 2019, she moved into her current role at Legal Aid Alberta as Senior Advisory Counsel for Family Law and Immigration. In this role, she is responsible for Legal Aid Alberta's articling and student programs, liaising with various levels of court on policy and program delivery, including issues that relate to the representation of children in high conflict parenting matters, emergency protection order program, and representation of victims of family violence. One of Andrea's passions is representing children. From 2000 to 2007, she was a member of the Children's Rights Panel with the Office of the Children's Lawyer in Ontario. God, I'm tired. In Alberta, she represented children and mentors other lawyers in child representation work. In April of 2022, Andrea established and now oversees Legal Aid Alberta's Child Representation Panel to ensure child clients receive the highest quality of representation from counsel who have training and experience in this specialized area of practice. And on April 23rd of this year, she received her KC designation. So without further ado, here's Andrea.
Oh, thank you. Thank you very much, everybody, for having me here today. I'm going to do my best not to trip on all the cords, so if I fall, please. And I will confess in advance, I'm not a techie in any way, shape, or form, so there may be issues that may happen from time to time. Thank you so much for having me here today. I'm delighted to be in Yukon. This is my second time here. One of my sisters lived here for a period of time, so I had a chance to visit a number of years ago. I'm going to few disclaimers right off the bat. I am not a professional trainer by any means, any shape or form. So this is just one counsel sort of sharing what I do, what we do. And I have the perspective of what happens in Ontario and also the perspective of what we do in Alberta. That's not to say Alberta is the center of the universe or Ontario is the center of the universe. Every place does things a little bit different, but this will just give you some ideas of how we're doing it, and it may help. And I'll try to look at this is Alberta, this is Yukon, this is your legislation, that sort of thing. So here we will get started. So first, we're just going to talk about an overview of the day. And one thing that I'm always told, my agenda is going to be fairly ambitious. So there may be a lot happening today. So first part of the morning, we're just going to talk about Representation 101, back to law school. What are the basics, what I need to know and should be talking about? Why should we listen to kids? Why bring them into it? We're going to talk about the convention. We're going to talk about when it might be appropriate to appoint counsel for children. What are those cases that it should be on? What are those cases that it shouldn't be on? We're going to talk about role of counsel. That's a big issue in many provinces. I'm not sure if it's such a big issue in Yukon. What role does counsel take? When do you step outside of an advocacy role and do more of an amicus role? We're going to talk about guidelines. What are the guidelines? What should be the guidelines? It's my understanding, and correct me if I'm wrong, that Yukon is looking at revising your guidelines for representation of children. So maybe there may be some best practices and ideas that come from today, but what should be those guidelines? What should be the standards and competencies for people doing this? When I oversaw the lawyers at when I was in Ontario, to get on the Office of the Children's Lawyer panel was an incredibly competitive thing. Not every lawyer who wanted to do this work got to do this work. You had to compete, you had to have training, you had to have experience, and those were the standards. When I moved to Alberta, so to get on the Office of the Children's Lawyer panel was a feat in and of itself. When I moved to Alberta, it's a little bit different there. The court, and we'll talk more about it a little bit later on, but on high conflict stuff, the court has to make a decision to appoint counsel. And then they will ask Legal Aid Alberta to appoint a lawyer. And when I came to Legal Aid Alberta, they were given the certificates to just about anybody. So Legal Aid has a bit of a hybrid model where we have staff lawyers, and we also have lawyers in private practice who take our certificates. There was just no checks and balances of where they were going. Sometimes they're going to articling students, sometimes internally within the staff office that I managed, I had very high standards. Lawyers had to practice a minimum of 5 years. So you have to understand the ins and outs of family law. And you have to understand representing parents in the various types of matters before you take on that type of role. And that's was always my philosophy. So I had really high standards for when my staff lawyers could do it, but it was going elsewhere. So we worked on some representation standards and competencies as to what should people have before they even consider doing this, and then they have to apply. Then we're going to talk, which I think is one of the things people really want to hear about, is meeting with kids, interviewing with kids. How do you do it? Who should be doing it? Who maybe should not be doing it? Having a real knowledge of the ages and stages of development of kids. So what to expect from a 4-year-old, you may or may not want counsel for, but what to expect from a 10-year-old, from a teenager. Different ages and stages, their skills are going to be different, their knowledge is going to be different, their ability to communicate is going to be different. So we're going to talk a bit about that. Then we're going to talk about how important it is. Kids are not adults. It's not like just bring in your adult client, they're going to understand everything you say, you ask your questions, and away you go. You have to build rapport and trust. Kids have, they're not going to, you're a brand new person. They don't know you from hole in the wall that their parents are telling you go see or the director of children's services. And I apologize in advance, I may use different terminology for children's services, and that will correct me when I say the wrong word, please. But you're going to talk to a stranger. So you have to spend some time building a rapport, building trust to get kids to open up. So we are going to talk about some tips and tricks and how to assess capacity, which helps you determine what role you're going to take. And we're also going to do role play. So we have a couple of, I keep calling them kids, which is probably not the right term, but a couple of young students coming in from the MAD program who are going to do a bit of a role play with us. So there's copies of the role play over here. I am a paper, that they're not my friends, but I seem to kill a lot of them. I am a paper person, so I bring paper. So there's going to be 3 different PowerPoints today. There's copies of all the PowerPoints so you can jot some notes down. I'm also one of those people, when I do a PowerPoint, I don't just have 3 words on it. I go to sessions, I leave, I can't remember what the 3 words meant, I can't remember context. I tend to put a lot of detail in, so you leave, you've got something to look back on and remember what we were talking about. So then in the afternoon, hopefully we get through the role play before lunch. Then we're going to talk about what are some best practices. So as children's counsel, one of our roles that we take on is actually talking to some of the professional collaborators who are involved with kids, who might you want to talk to help you get that broader perspective of what's going on with this child. And even in the high conflict work, you may need to get child welfare disclosure. Again, another disclaimer, most of the work all of the work that I do now is in the high conflict parenting matters. I don't represent at Legal Aid Alberta. We represent the vast majority of the parents who are involved in the child welfare system. So we don't do the representation of children in the child welfare stuff. I have had experience doing that in Ontario. So I apologize if a lot of the comments are more geared to high conflict parenting stuff. So then we're going to talk about when do you get child welfare disclosure, how to make use of it. Then we're going to talk about how do you share the views. Counsel, you're an advocate, depends on what judge you're before. I know in Alberta, what judge you're before, sometimes they're just so happy to hear anything about what's going on with the child. They'll let you say anything and everything before the court. Other times they're going to be really strict about how you get that evidence in. There's a Strawbridge case out of Ontario which says counsel can't be witness and you can't give evidence from counsel table. Half the time, judges will let you do that. Other times, particularly if you get into a trial, then they're not going to let you do that. You're going to have somebody to give that evidence. We're going to talk about all the different ways, how you might cross-examine people to get that evidence. Do you need an expert? I'm not sure here. My sense is there's not a lot of files that family law files that go to trial for. It seems to be kind of what I've heard. But when they do go to trial, you do need an expert, and how are you going to get them? We're going to talk a little bit about judicial interviews too. That's something that seems to be on a bit on the rise. I wouldn't say it's super prevalent, but I just authored with Madam Justice Loparco and one of my colleagues, Jeff Feller, a paper on judicial interviews, when they might be appropriate, and what might the child's counsel's role in that. Are you going to be part of that? Is it going to be a recorded session? Who's going to be present, and what might help in child's counsel sort of help a child get through a judicial interview if the court decides. Then the grand finale later on today is going to be views from the bench and bar. So you're going to hear, and I always find when I do these sessions, I always end with the bench and bar, because people want to hear what works for the judges, what's helpful, what's not helpful, some tips, some tricks. So we're going to talk about when they themselves think child's counsel should be appointed. We're going to have a very senior practitioner who's going to talk about when she's been appointed and when it's appropriate. What the court is looking for child's counsel. What is it you want to see them do? What do you want to see them provide information to you? Any concerns? There's lots of concerns about child's counsel. In Alberta, I can tell you it's a high-risk practice doing children's counsel's work, particularly in the high conflict stuff, because parents often don't like what you have to say or what you're sharing, and they'll make complaints to the Law Society, they'll make complaints to Legal Aid Alberta. So you want to have some best practices so that you're doing sort of the same thing every time, so you can defend your process that you're using. We're also going to hear about tips from the judges and senior counsel, tips for children's counsel, what they want to see more of and what they want to see less of. So if you are doing this work, then you're going to be in a better position to be able to represent your child clients and also give the court what they're looking for. And then we're going to have a discussion at the end, and for me to decide this discussion, but what should there be? Should there be a standardized order? One of the things in Alberta that we have, and I've worked really closely with the bench on, is having a really standard order when counsel is appointed for the child. It talks about the role of counsel. It talks about the power that you have as children's counsel to contact collaterals, to get information from them, things you can do and cannot do. So when we're having that discussion, make sure you have the order. It helps a great deal. A lot of the terms that are in there are because we've had bad experiences on things. So we're trying to cover them off to make sure children's counsel, like who can be there, like you get to meet with your child on your own, just like you would with an adult. Parents sometimes think they should be in on it. Obviously not. So the order sets out you choose, rather than counsel telling you what you should be doing. You choose when you're meeting with the child. You choose when you're meeting with the child. That sort of thing. So that's kind of what we've got planned for the day. Again, a bit ambitious, but we will see. So first and foremost, people say, why? Why should we actually involve kids in, why should we get them involved? Generally, and again, I'm not a scientist in any way, shape, or form, most kids want to have some input. Some input, particularly in the parenting arrangements ones, they're the ones that have to live back and forth between houses. They want to have some input, not that they're decision makers. And you're going to hear me talk about voice versus choice throughout the day. And that's something that we talk about a lot in Alberta. Kids can have a voice, but they don't necessarily have a choice. And certainly the court is the ultimate determiner of how much weight they're being put on the child's views and preferences. So why do we care? Kids have a right. We're going to talk about the United Nations Convention in a little bit. They have a right to be heard. And actually, as children's counsel, it's been my experience, and maybe it's a different experience for some of the counsel here, the court really does pay attention to what you say as children's counsel. You're not the decision maker, and never let the child think you're the decision maker, and never believe that yourself, but they do put a lot of weight on. So having credibility with the court, having the court understand what your process is and how you come up with what you're sharing with the court and how you've dealt with the child, that's really important, because they're going to put a lot of weight on. So I always say to students and to junior lawyers, as a lawyer, one of the things that you can control is your reputation. You control your reputation. And so if you are going to do this work, build a reputation of doing it really competently, have a good process, use best practices so that the courts can rely upon what you're saying. If you're seen to be somebody who's not trustworthy and not, kids, that's what they said, but I don't like that idea, so I'm gonna go with something else. Again, no matter what role, and we're gonna talk about role of counsel in a bit, but no matter what role you're taking, you should always be letting the court know what the child's views and preferences are. Even if you're not necessarily supporting that, even if you're an amicus, the court should always know what that child wants. As I said, most kids do want to say in what, not that they're the decision maker, but they want to say what's working for them, what's not working for them, what might be able to be changed in their arrangement to help them. Again, particularly in the child welfare stuff, sometimes you have kids who, doesn't matter how awful the situation is at home, doesn't matter how much they're being abused, they may still always want to be with their parents. And that may always be what their views and preferences are. So you have to share that, but all the other evidence is going to be there too. I also find when you have children's counsel involved and when you get the voice of the child before the court or even before parents in a meeting, it helps them focus on the child. Because so many of us have had so many years of high conflict cases where parents, because of the nature of it, they get so focused on themselves and their interests, they forget kids are not property. They're not to be divided and cut in half, sort of thing. It helps them focus on what the court has to make a decision on what is in the best interest of this child, not mom, not dad, but what's in the best interest of the child. And I find you'll see me when I do the role play, I try as best I can to take notes. Again, no computer is out because I can't type that fast, but I take notes and I really try where I can to catch the language of the child. What exactly does the child say? And when I do my notes, I always try to put in quotation marks so that I remember parents know how the kids talk. They've been around them all their life. They know what resonates. Does that sound like my kid or does that not sound like my kid? This is my kid. So I find when you have meetings with parents, I generally go through a process and then before I say anything to the court, I usually meet with the parents, their counsel, and everybody hears what I'm going to share by way of the children's views and preferences at the same time together. So there's no independent chat here, independent chat here. And often you can settle facts. It's interesting, the Alberta Law Reform Commission is doing a review of the voice of the child in Alberta and looking at, and one of the things they were looking at was reported decisions. And that was what they're basing some of their stats on. And I'm like, in the cases where you have children's counsel, chances are the work is being done well before we get to a reported decision. It's, as children's counsel, my philosophy is you are to be part of the solution, not part of the problem. You're here to help people resolve things, hear from the kids and try to see if you can help them resolve their matter. And when parents hear what their children want, often they're pretty reasonable people. They'll do some arrangements that work for them. And the role of children's counsel, decision makers have more information about the child and the context for what the child's interest. How many times have you read affidavits done by warring parents where there's nothing about the child? There's nothing about what this child is like, what does this child do, what grade they in, other than their date of birth. Nothing about what the child, it's all about the parents. So you're the one that's going to be helping the court by bringing information about this child. What's important to this child? What's the child involved in? What sort of activities do they have that may impact whatever parenting arrangements you may be looking at? I tap on the hands all the time too. So I think the better question is, rather than why care about the child's voice, is why not care? Why shouldn't we be listening to kids? Again, not decision makers, not a choice, but just providing some input of what works for them. Again, I said most kids, they want to have some input. It's their lives. They're the ones that are having to go through this. The toxic stress that kids go through from high conflict parenting has lifelong impacts on kids. And there's a couple of handouts over there on ACEs. I'm sure people are familiar with ACEs, like adverse childhood experiences. When you look at that and you look at kids, toxic stress and being involved in the caught in the middle of parents' disputes, it can be just as damaging on children as other types of abuse. So really knowing they want to have some input, and you need to know what are the effects of toxic stress. What is the effect of this high conflict dispute going to have on these kids, not just now, but for many years to come? And when you focus that on parents, you know that if you continue this war, this can have impact on your kids' relationships in the future. It can have impact on their ability school, to focus at school. Often kids who are involved in high conflict, toxic stress end up with alcohol issues, drug issues, self-harming. Is that what you want for your child? You talk about that, often parents will become much more amenable to resolving matters. And there's significant research out there that kids want to be heard. And there's a lot of people think, and very much there was a philosophy for many years, keep kids out of it, keep them out, protect them in any way, shape, or form. But there's less harm, and there's significant research that says there's no harm in a child meeting with a lawyer or a social worker or a professional. More harm is done by toxic stress, by them being involved in the middle of it. So that's one of the things to keep in mind. And as I said, parents tend to focus more when they hear what their kids want and what works for the kids and what's not working for their kids. And hearing from the child also allows parents to really think about what is the impact of what my behavior is and what we're going through. How is this affecting my child? Because that should be the foremost thing in their mind. And as I said, there's no evidence that involving kids in the process is harmful to them. I'm not talking about sitting down and reading the affidavits to kids. Did you know mom said this and dad said that? Is that true? You're not there to cross-examine them on every allegation. I don't know, in Alberta, when Children's Services is involved, they do what is called a court report, and they put every terrible thing that a parent has ever done for the last 20 years. Not only the parents, but the grandparents, everything that's in there. You're not going to sit and read that to a child. You're not going to review that. You're going to find out from their experience. That would be harmful to the child, but finding out from them what's working, what's not working, what the wishes are, is not. And the reality is, when kids have some input on their schedule and kids have some input on what their living arrangements are going to be, they're much more likely to go with it, to live it, and not be running away. If you put kids in a situation where they really don't like what they're doing, they're going to be at risk to run. They're going to be at risk for other things. So them having a bit of an opportunity to meet with a lawyer or social worker or a judge can also provide them some opportunity to have a voice. And from a legal perspective, we also have obligations. We're all here, we're lawyers. On an international level, there's the United Nations Convention on the Right of the Child. Canada is a signatory. There's obligations there that children have the right to participate. And the legislation that we're all dealing with, the Divorce Act, the Child and Family Services Act, do I have that right? Yeah, Child and Family Services Act, as well as the Children's Law Act, also has some obligations about hearing from kids, their views and preferences. Okay, couple of cautions. You're gonna think, oh, she wants every child to have a lawyer. That's not what I'm saying, but a couple of cautions about children's participation as well. Sometimes the information obtained may not be reliable, as the view expressed may not reflect the true feelings. And you may see those in cases where you've got coaching, undue influence by your parents. Sometimes kids will say different things to different parents. They'll say, Mom, I want this, Dad, I want that, or the child welfare worker, I want this. Sometimes that's what they're saying is not. So it's really important when you are meeting with children, not a one and done deal. There are places where some provinces have voice of the child reports where a lawyer meets with a child, maybe once, maybe twice, and it's a one and done, and that's it. When you have children's counsel, you have ongoing obligations. While the matters before, it's not, this is what Johnny said to me today, and that's what we're going to go with. You're going to hear, you want to see consistency in their views and preferences. And you'd be amazed, and I try where possible, it's not always possible, to have different parents bring the kids to meetings with me, because sometimes they're really influenced by who's outside the door, who's waiting, who's talked to them the whole way here. Like, you'll find some kids will come in and they're like, they're just so stressed, and the minute they open their mouth, it's like, I have to tell you about this, I have to tell you about that, and my stepmother said, make sure I tell you this, and they have so much, and I want an obsessive obligation of the house. I'm like, what? I want exclusive possession of the house? Yeah, that's what I want. Like, they can be so prepped on the way to the meeting. So you really try to rotate where possible. Children feel caught in the middle, and they said they'll tell each parent what they want to say, and they may be manipulated and traumatized by what's happening, and they may feel like they have to. Sometimes in children's services matters, kids feel like they have to tell the parents that they want to go home when they may be perfectly comfortable with where they're living at this point in time. And kids don't understand the process. They don't understand, and that's your job. Your job is to hear their views and preferences, but also explain the court process in child-related terms. You're going to talk at their level, depending on what, and you're going to share with kids what you need to share, but that's going to be a decision how you share it and how you express what's happening in the court process. Just a couple of other things, views and experiences, and lots of people talk differently about this. So evidence of views, that's children's perceptions of the relationships and their expressed preferences. So that's subjective from their perspective. And then the evidence of experiences, children's statements about what happened to them or what they observed about factual issues in dispute. Because sometimes, and that's an objective matter, sometimes when people appoint children's counsel, they kind of think you become an investigative reporter. You're going to get to the truth of everything. You're going to find out exactly. You're not, and I tell people that really quick, I'm not an investigative reporter. If you think you need that, then you probably need an assessment done, because I'm not trained to do that, and that's not my role. My role is to be there for the kids. My role is not to get evidence for the parents. It's to put the child's views and preferences before the court. So again, if a child, sometimes you'll ask kids, they'll talk about domestic violence that happened in the family when they were 2 months old. Well, how do you kind of know about that? Oh, my mom has told me, or my dad has told me, or I saw this and that. So what their evidence may be of their experiences and their views may be influenced by other people and what they've heard. So what do kids need? Sometimes we forget. They need age-appropriate information. So they need to know what's going on. Sometimes kids don't know that their parents are in a dispute, and sometimes you're the first one that's telling them. So you'll hear me later on when we do the role play. I'll ask kids, like, well, we kind of told her to come to see me today. You're a kid and you're trucked off to somebody's office. Somebody's going to presumably have told you something. And some kids, particularly kids who are involved in the child welfare system, have been to so many people and interviewed by so many people. So what information you're going to provide them is you're going to do that very carefully and do it at an age-appropriate level. And they need to be able to have age-appropriate input in decision-making and planning. Not that they're the decision makers, not that they're going to be having a choice, but have some input. And you'll hear me say when I talk to the young ladies, and one will be a male this afternoon, I'll talk about, at my start of my meeting, we'll talk about solicitor-client privilege. And we'll talk about just because you have a lawyer, because sometimes kids think if they get a lawyer, or their parents think if they get a lawyer, then they're the decision makers, the kids get to decide. And you'll hear parents, some people think at age 12, you automatically have a right to choose everything. That's a myth. Certain things you do. You can be charged at age 13 with criminal matters, but you don't have an automatic right. The older a child is, the more a court will pay attention and put weight on their views and preferences. But what a 5-year-old or an 8-year-old may tell you and what they want versus what a 15, 16-year-old, good luck at 15, 16, they're going to do whatever. Quite honestly, they're going to do whatever they want at that point, and they're going to vote with their feet if they don't know. It's also important for kids need to know that it's not their fault. It's not their fault that their parents have separated. It's not their fault that they're involved in all this. And it's okay to love both their parents. So many kids get caught up in loyalty disputes. They think they have to love only one parent, not the other. And I usually share with parents, and I share with kids, like how lucky you are that both your parents love you so much, that they want to spend so much time with you, and that they want to make sure that they both get to have involvement in your life. So it's okay, and it's okay. Sometimes kids think, well, I'm not allowed to say that. I'm not allowed to say I want to spend any time because that makes mom really sad and that makes dad really angry, sort of thing. But it's okay for them to know that it's okay to love your parents and to see, feel, and hear the messages, not just be told. To have some input. Again, not decision makers, but have some input. So we all know that kids need stability. They need consistency. Most kids want to know what and again, I'm talking a lot about the high conflict stuff. They want to know what their schedule is going to be. They want to have some input on that schedule. And they want to know that it's going to be Wednesdays and it's going to be every weekend or it's going to be every other week, that there's going to be consistency. There's not going to be tons of changes. They want to have quality relationships. And I say quality, not quantity. How many times do parents get in a war of how many hours? Want to get to that 40% for child support. But it's the quality of the time you spend with your child should be the priority versus the quantity. And kids want to be kids. They don't want to be the ones sending messages back and forth between the parents. They know, oh, it's up to you. You get to decide if you don't put that on them. if there's court orders, they have to follow court orders. They need to understand that. And financial support. How often do you see files where the parenting disputes are really geared to child support? And are they geared to the financial issues that who lives in the house and things like that? And you'll see in one of the scenarios, there's a reference to dad saying, I'm so sick of paying child support, all my money goes, how often do we hear that sort of thing? So United Nations, I assume everybody's familiar with the convention. If you're not, don't worry about it. There are some handouts, some really fun kid-appropriate handouts on all the rights that kids have. So as I indicated, we're a signatory. The relevant provisions that you need to know are set out here. Article 3, that in all actions concerning children, whether undertaken by public or private social work institutions, court or administrative authorities or legislative bodies, the best interest of the child shall be the primary consideration. And that's consistent from the convention, to the Divorce Act, to your Children's Law Act. Best interest is the priority. Article 4 requires that states parties shall undertake all appropriate legislative, administrative, and other measures for the implementation of the rights recognized in the present convention. So in Yukon, is the court pretty good here about following the convention? You have Donna Martinson, who is probably one of the leading justices and academics in the world or in Canada at least. I don't know her personally, but I started in Alberta, the CBA Child and Youth North section. So when you co-chair that or you're the president of it, then you're automatically on the national CBA committee, and she was on that, and I think she's retired and living in Vancouver now from what I hear, but her decision is probably one of the primary decisions used in Canada on the convention. So Article 12 is the key one from my perspective. State parties shall assure the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. So in all matters that is life. Now, I'm not saying every case you need to have children's counsel and have a voice, but certainly based on the convention, and for the purpose, the child shall in particular be provided the opportunity to be heard in any judicial or administrative proceeding affecting the child, either directly, which could be through a judicial interview, or through a representative or an appropriate body in a manner consistent with procedural rules of the nation. And it's interesting, I was in a session not long ago when they were talking, Rachel Birnbaum, who does a lot of work with Nick Balla out of Ontario. She's a social worker and Nick is a prof at Queen's. They do a lot of research across Canada, and they said really where a child lives in this country really depends on how much the voice is listened to. If you're in Ontario and you have the benefit of the Office of the Children's Lawyer, chances are you're in a child welfare matter or a family law matter, chances are you'll get a lawyer appointed for you. If you're in Alberta, if you're in BC, they have a number of mechanisms. If you're a kid living in Newfoundland and Labrador, chances are your voice will never be heard. And there's no consistency. It's because we've looked at various things across, and there's lots of research done about what happens in every province, and it's really quite different, and there's no standard sort of requirements across Canada for what it should look like. And because we are a signatory, then we have to ensure that the views and preferences of children about their needs and their interests are presented to judges and all decision makers.
You've touched earlier on the age of 12 years old now. Up here, so it used to be the norm over years because the appointments get done by the PGT. I mean, the court makes the recommendation. But it seems to me nowadays a sort of PGT is more rigid in terms of the 12 years age requirement. I've had it in long ago where they were more flexible on that, because to just have a rigid coach of 12 years old does not make sense. People, just as adults defer children defer. I've had a case once with two sisters. The one was 12 and the one was 10 years old. And the 10-year-old one was so smart. It was one of the smartest child clients that I've ever had. And she said to me, "Look, I know what it's all about. It's all about the child support."
Yeah.
So, how do you get past this hurdle of 12 years old to, I mean, our former Chief Justice here used to say, when attributing value to the opinion of the child, if it's like he said, the child who's 12 years old votes with his feet, meaning he's going to go where he wants to go, and if it's a young child, you just pick him up and take him to that. But again, 12 years is not a magical touch.
And 12 years, sorry if I made it sound, I'm not saying 12 years is the age that children have to be, just certain things people think at 12, that's when they magically get to decide. So in Alberta, on the child welfare side of things, the process is, and we'll come to it in a few minutes, but I can talk about it now. The process is either the court makes an order, and the court can make an order for any age range, and those are done through what is called the Office of the Child and Youth Advocate's Office, and they have a program called LRCY, Legal Representation of Children in Need, and they take files from babies through to 15, 16-year-olds. Again, there's no set age, and then the high conflict stuff, and Alberta, it's kind of all over the place. Justice Pfaff did a decision a few years ago when he said, kind of 12, but not. Each and every case you have to assess what is the age and stage of development of that child and what's the maturity level. I believe, and I certainly can be corrected, it's my understanding here that a court can make a referral, I assume they do an order and a referral to the Office of the Public Guardian and Trustee and counsel, as I understand it, if the child is over 10, so 10 seems to be the age here, and Kayla is nodding at me, so I'm accurate with my information. 10 is the age here that the rule will print on. I think the court makes a recommendation generally over 10. If the child is under the age of 10 and counsel are wanting a counsel to be appointed, the lawyer has to do an explanation of why do you think this child who's under that age needs to have representation, needs to have a voice in these proceedings. Now, in Alberta, we have seen cases. I've seen cases of babies where there's maybe nobody else involved, but they'll appoint counsel. I've seen cases for younger children. So it's up to counsel, as I understand, and Kayla, please tell me if I'm wrong. It's up to counsel to explain why it would be appropriate in this particular case for this child who's under the age of 10. And it can be for a number of reasons. It can be there's a sibling group and there's a risk. And we'll talk about PUCHAC in a few minutes, which will list all the reasons why counsel should be appointed. One of those sort of scenarios, so you can make use of some of that. Why maybe that there's a sibling group and there's a risk of separating siblings. It could be you have an incredibly articulate child, but you may not know until you met with the child. So I'm not sure if that's part of the issue, and that's we can talk about that.
They're saying that their views, they need to be capable of forming their own views and communicating their preferences, and might be appropriate for a mature younger child to have representation that if you can't assess
the child,
so and it's not so how are you assessing that and asking for it if you can't get through the door?
So does the Office of the Public Guardian and Trustee allow counsel to meet with the child to help make that assessment? Yeah, I'm kind of putting you on the spot here. So.
Sorry, I'm kind of different regarding
just
for any of you who don't know me. Yes, the child lawyer guidelines actually require, it's a requirement in the guidelines, that the age for sort of the automatic age for appointing a child lawyer
is 10. Yeah.
Anything under 10 in the guidelines, there is a requirement that there is written rationale provided to the public guardian trustee that provides an explanation as to, as you just said, sort of why or how that child is expected to meaningfully engage with the child lawyer. My understanding is that it's during the family matter or the matter for the court, one party or the other, the parents, if you will, would ask or recommend to the judge the appointment of a child lawyer. And so it would be whichever party standardly, it's whichever party has asked for the child lawyer that would provide the explanation, or their lawyer would provide their explanation in writing to the PGT about why they feel that that child under the age of 10 can, would benefit the needs of the child.
So counsel really do need to have a really good counsel for the parents, that is, really do need to have a good discussion with their clients as to why they think it's appropriate for the child and share that information. So there's no opportunity for a children's counsel to sort of meet with a child and sort of make their own decision as to whether they think it's appropriate or not. Or once you do the recommendation, once you do the appointment, then you expect them to report back if they don't think it's appropriate.
Exactly. Yeah, and that has happened with older children as well, children who are older than 10, where the child lawyer has said, I've met with the child several times. And
they don't want to participate.
Yeah. Is appropriate for, whatever reason.
Yeah, and sometimes you have counsel for one of the parties. You may get the information from the client, from the parent, who says, well, when you discuss the children, and mom or the dad will say, well, that one who's 9 years old, he's pretty smart and vocal, and
Yeah, so I think it's up to, so then I kind of think it's on council to really do good letters if you really think it's appropriate to have. And again, as you look at changing your guideline, I'm not sure if there's any room, and I'm not putting you on the spot here, for the OPT to review what, are those sort of set in legislation, or are those your internal guidelines?
The guidelines are policy.
Yeah.
I think they're from 2004 or 5, maybe. I'm not really sure.
Everybody familiar what we're talking about with the guidelines? Anybody not know what we're talking about? Only me.
So, just to make a little contribution to what my friend has raised there, and I find a lot of differences between Ontario and Yukon. Ontario, the starting age is 5 years of age, and Ontario does have 3 different models for appointment. Number one is they can appoint an assessor where alienation is an issue.
Yep.
A clinical
social work
assessor
assist,
under Section 30 of the Insurance Law Reform.
Yep.
Ontario also does appoint a child's lawyer under Section 112 of the Courts of Justice Act. And then Ontario also does appoint an assessor for the voice of the children's report. Now, those 3 models are 3 different things, and usually counsel are in court arguing what model of appointment should be made by the court, and the court will have to make a determination on the recommendation to be made. Here in Yukon, just one model, an appointment of the lawyer, and often the report I see, sometimes I find them scary because it does not really standard of what Ontario will accept. I will have them struggling, where you see the child's lawyer making conclusions that are not supposed to be part of the report, reaching conclusions that only a court can formulate based on the facts and the circumstances of the case. In one I received, the lawyer recommended that the mother should have nothing to do with the child as well. That was actually the language. And when I saw that, I couldn't help shaking to my feet as to how did this come about. In Ontario, we have 31 days from the date of the report to set a conference date and challenge that report, and ultimately can have it struck, especially all the conclusions or the entire report. We don't have such systems here. It just goes in the way you go. There is no evaluation most times after elimination, because there is no clinical assessments. So all of these I find really highly inadequate. And as a member of the panel in Ontario, I look at the reports, in pages to pages, and so inconclusive in its very nature. I think there's really a need for a reform of the system here to be the standard that I've seen elsewhere, because the way it comes, the way you have a look at it, I'm wondering how this come about. I think there's the whole couple of reform that is required for the standard here to meet what is expected of the child lawyer. Because in Ontario, we have the voice of the child meeting, as you will know. Where the parents must, before you release your report, you call the parents. I've seen a situation where no meeting was held. The mother didn't know that it was even ongoing, that she started at work. She met only twice with the father and released the report. In Ontario, you have to meet with both parents. You have to make an arrangement, even when the other parent does not have a child, to bring in the parents for you to have a talk to see if the views are different. And if the views are different, then you have to meet the child at a neutral location, which the child's lawyer usually goes to the school for a third conversation. You formulate all the reports simply on the basis of what the child told you. The court makes the conclusion. But here, I've seen the reports delving directly into the substantive nature of the cases, not just reporting what they observed, but instead reaching conclusions that only a court of competent jurisdiction can reach.
Certainly, Children's Counsel is not the decision maker. And I think that's really something that's really important to share with kids right up front. I'm not the decision. Courts will pay attention. And at the end of the day, when we have the panel, we're going to talk about what may be some things that as you go forward in this province, because I understand you are looking at potentially reforming the guidelines and reforming some of the things. So we'll have an opportunity to have some more discussion about that. But you're right. It, as I said, depends on where you are in Canada as to what's the nature of the services. I think you had a question. You had your hand up.
I was just gonna say that the courts are also the gatekeeper of some.
Exactly. They're the ones who have to make the decision.
Recommendation.
Yeah.
So we still have to, there's
You have to-
often times where the courts will say, we're not prepared to recommend a child lawyer for us.
Yeah.
So there's sort of that two-step, like it goes to the court and it goes over to Kala.
So Kala is not necessarily the complete decision maker. So it's up to council. If you want to have children's lawyer appointed, then we better
Say,
articulate.
if I get an order recommending a child lawyer, I make every effort to assign. And if the child is under 10, if I get that recommendation or that explanation provided, I very rarely would say no. So it's a requirement in the guidelines, which is a policy, which I was not involved in developing. And maybe there's people here who were that can speak to who was involved in developing that. But as a policy, I am trying to model it. And so I just remind folks, if you are representing either party and was involved in requesting a child lawyer for a child under 10 to be sort of
Do a really good job of
provided me
that.
with that I won't sign until I get that explanation and rationale.
Do you always apply the recommendation, or if you have counsel who are agreeing on both sides of the file, that hey, you know, we've got a 14-year-old child here who needs to have their voice heard and we'd like to maybe not go to court.
I require.
Yeah, I require. The act.
Ontario does have a form system where after the appointment, within 31 days from the appointment, each party must fill the form and have it filed. And it's on the basis of that form that the evaluation is fully done. And usually the evaluation is looking at as they have been conducted in any way that affect the well-being and safety of the child. I have a case right now that the court has just ordered that I believe a 7-year-old that counsel should be appointed for. I believe the child is 7 and the elder sister is the elder child is 10. I'm just learning right now that there is a process for me to file any document whatsoever to request for the appointment. In Ontario, it's straightforward that immediately after the appointment, the parties are required within 31 days. Usually comes with the nature of the order because there is a special order form for the appointment of the children's lawyer. The court will fill it out. That order form also requires you to file the document within 31 days. For failure to do it on behalf of counsel for his clients, you will receive a no appointment decision from the office of the children's lawyer, and court can easily attribute blame on whose failure, on whose part was that. But if we can have a standard form that elicits information so counsel can clearly identify why the appointment is necessary or what safety concern and well-being of the child has been engaged.
And as we move on to with the PowerPoint presentation, there's the pre-check decision, which you'll have, which has really good listing of all the reasons why children's counsel should be appointed in one of those types of cases. So back to the convention, I won't run through all the slides. There is Justice Martinson's decision. Make sure you know that decision and have read it. In her view, all children in Canada have legal rights to be heard in all matters affecting them, including custody cases, again, before the changes to parenting language. Decisions should not be made without ensuring that those legal rights have been considered. These legal rights are based on the United Nations Convention on the Rights of the Child. So again, you're making arguments. Here you go. The convention says this. So what's the jurisdiction point? And again, if I'm wrong, please highlight. So as I understand, in Yukon, the Supreme Court has the ability to appoint. The Divorce Act says using preferences of the children, doesn't have a mechanism in it to say you must appoint counsel, but to get the views and preferences. And you have your Children's Law Act, Section 168, and the parents' patriarch jurisdiction. Do the courts use that all the time here too? Where there's a gap, there's not specifically set out in the legislation, they can fill that. And your territorial court, as I understand, it's a court of statutory authority, and child welfare matters are dealt with there. And Section 76. In Alberta, we have our higher court, which is the Alberta King's Bench, and it's a superior court. Again, it can hear matters under the law. So the Supreme Court and the Superior Court, very similar between the two provinces, province and territory. Divorce Act, Family Law Act, deals with property matters. So both they can in that court. And in our Alberta Court of Justice, which is a provincial court, again, a statutory court, Section 112 of SACFIA allows them to appoint, and the Family Law Act, which I don't think you have a Family Law Act here. It has a specific provision regarding appointment of counsel under Section 595.3. But one of the things in that is you must talk about who pays. Because that's an issue across the country as well. Who pays for the appointment of children's counsel? It's a bit different in Alberta. If counsel is appointed on a high conflict matter through Legal Aid Alberta, the parents have an obligation to repay legal aid, depending on their circumstances. So you'll have very affluential people who can privately retain, or they'll ask Legal Aid Alberta to appoint, but they must repay or make some efforts to. A lot of my files, I'm able to collect on that. But the rate that we pay lawyers is $125. In the child welfare matters are done through the Office of the Child Needs Advocates budget. So, and they appoint, and again, they appoint on any age range, but again, they have some discretion as well as to whether or not they appoint for it. But generally they will. So that's what your jurisdiction is. Who provides it? It's appointed. So a court, as I understand it, please correct me if I'm wrong, court makes an order. Do they make an order or just a recommendation?
They make an order.
Order with a recommendation in it. And then the Office of the Public Guardian and Trustee appoints for both child protection as well as parenting. In Alberta, as indicated, LRCY does one. And the high conflict stuff, we do it through Legal Aid. Or if parents can afford, they can retain any order they want to do it. But you can't have one parent retain. It's got to be on the consent of the parties. You can't have one lawyer. And then that's where this whole discussion came through Kuchak, is because one parent just went out and hired their own lawyer for the child.
Can I just, if you go back one slide?
Sure.
The only authority that I have to appoint a child lawyer is under the Children's Law Act or the Child and Family Services Act. So I have no authority to appoint under the Divorce Act.
Interesting. So what do you do in the Divorce Act matters? You don't appoint at all?
I have no authority to appoint, so,
Also, it goes to our children's law.
Yeah. So even if it's a Divorce Act, they
We still follow
plead the
So-
Children's Law Reform Act just to ensure you get it under. Okay.
Like the
got it.
Divorce Act still provides,
The
but-
factors, yeah.
correct, yeah, but the actual appointment is those two acts, whether
Okay.
depending on whether
interesting.
you're preferred territorial or supreme.
And territorial court doesn't deal with family law deals with child
Child
support,
protection.
child protection, but they don't deal with any of the parenting related matters. Okay, perfect. Thank you for clarifying that.
You might mention earlier about the form of the order, all the powers that are
Yeah.
set out in the order, which we don't have here. Here the order is recommendation that child lawyer be appointed. But I'm interested in, I would like to see your order from Alberta was sitting on the, is it?
Right over there, yeah.
Because we've run into problems in the past, especially when you deal with the Department of Education. They're just resistant in terms of providing information to you, even if you say, well, you know, I've been appointed as child lawyer.
So we have worked really hard on having a standardized order. It's used in the higher court. I'm still working with the Alberta Court of Justice to get them to use it as well. But it talks about who's going to be appointed. It talks about what role counsel is going to take. And paragraph 6 of the order talks about the power of the Children's Counsel to receive copies of reports, to receive copies of correspondence, to have production, to be able to do a questioning, to talk with the child, meet with them confidentially, alone, without whatever location, to communicate with parents, to meet with the child. try to be removed from council, to take appeal steps if necessary, to take other steps. And there's a very specific provision there about all third parties involved with the child and their parents, including but not limited to teachers, schools, child and family services, assessors, mediators, church personnel, visit supervisors, medical service providers, psychologists, and social workers have to provide information. So it's a mandatory thing. The one area we have tons of, still have difficulties, even though police officers are included in there, they often don't want to provide information directly, particularly if it's the RCMP. They have their own orders that they require for release of information. So this does go a long way. So when we want to talk to collaterals, I usually find out from the parents who are the professional collaterals. I don't talk to every auntie or every grandma or whatever. I want to hear from the professionals. And generally they'll provide information because it's 100% to court order. So this is one of the first things. We used to get orders from the lower court, Legal Aid Point Counsel. Maybe it talks about payment, maybe it doesn't say anything more, but we've worked with getting these standardized orders. So then as Children's Counsel, you have the ability to do the work you need to do without interference. And so I would highly recommend working towards the best practice of having a really good appointing order for Children's Counsel, because we'll help you with the work that you do. So yeah, there's copies there if people didn't see it. Again, we talked a little bit about this already. So Counsel for Children in Yukon, court makes an order recommend. Did have that right? Not right. Child is over 10, generally counsel is appointed. If a child is under 10, the party who requested the appointment of counsel for the child must write to the public guardian and trustee and explain why it's required. So that's where counsel have a really good opportunity to put in why. Again, you've already convinced a judge to make an order, then you convince the OPGT to do it as well. The benchmark, which I believe you shared with, is it reasonable to expect that the child can engage in a meaningful way? And we're not talking go to court, give evidence, understand, have the ability to meet with counsel and provide some views and preferences, follow your guidelines. And as I understand, the public guardian has no role in file management. You're not telling the lawyers what to do or what role they're to take, and there's no oversight. You appoint and you pay the bill at the end of the day. It's what I understand. So in Alberta, we have this Puchak case that came out in 2005. And 2005 is kind of when in Alberta they started to really think about the role of Children's Counsel and who should be on it. So one of the justices who is now retired, Madam Justice Tressler, did a whole weekend thing. It was before I moved to the province. And every lawyer who wanted to do the child rep work had to spend a full weekend doing training. But there were nobody, from what I understand, nobody was allowed to leave the room. They were not allowed to go have a cigarette unless they had her specific permission. And then really talked about, after this Puchak decision, what are some of the factors? Like, how mature is the child? Other allegations of abuse, other allegations of alienation, is there high conflict? So this next slide, literally, in Puchak talks about all the reasons why Children's Counsel may be appointed. So this may help, and this is taken from an Australia decision, but these are all the type of cases where it may be appropriate to appoint Children's Counsel. So if you're writing that letter to OPT, are there some of those things in there? Is it allegations of abuse? Is it allegations where a child is being alienated? Is the conflict between the parents so intractable? Is this the 20th time they've been in court fighting over this issue? Are there 15, 16 orders? It might be appropriate. Are there cultural or religious issues? Are there issues relating to culture? Are there sexual preferences of either the parent or the child? Is that a question or is that an issue in the litigation that needs to have some input on? Is the conduct of one or the other of the parents to the level of being antisocial, where we need that it might impair a child or seriously harm a child? Are there psychiatric or medical issues? Are the materials, when you look at them, you read them for both parents, neither parent looks like they're a suitable guardian. Sometimes I've had cases where I've been appointed as Children's Counsel where both parents were not criminally responsible and happened to meet in a facility and hook up and then, or appointed counsel for a very young child, and even that child could not articulate anything, but there was more of an amicus role for the court. And we'll talk about roles in a second. Is it a case where a child is mature enough to express strong views and preferences? You also, if it's a mobility case, often the court will want to know if it's a relocation matter, what's the child's views? Is it cases where there's a proposal to separate siblings? That may be where those cases where you may have a mobility or you're going to separate kids where a younger child may be involved as well, where you may want to include a younger child. Often the one we see in Alberta, custody cases where no one has counsel, the courts love to appoint children's counsel, so at least they're dealing with one lawyer on the file. So they'll often, I'll say to them, you really make the assessment that it's because in Alberta, it has to be a high conflict case in order, so not every case just gets children's counsel. And I'll say, you make that assessment that it's high conflict, right? And they'll give you that cute little smile, like, yeah, sure, I guess. Or they just want to have a lawyer on it. And it can be cases where the court's child welfare jurisdiction relating to a particular medical treatment. We've had, on the LRCY side of it, on the child welfare side of it, we've had end-of-life decision cases where children's counsel has been appointed for very young children to put those views and preferences, not views and preferences, but their interests before the court. And I'm generally not a huge proponent. Again, my office acts for most of the parents on these files, so we're usually really critical of children's counsel on it. But that was one where you had a child who could not articulate whatsoever, but it was really helpful to have children's counsel on it. So we have another decision that came out of Alberta, the FEF decision, and Justice Fett said, no, it's not just one of the factors in Kuchak. You really have to think of, in Alberta, we have some judges who love children's counsel, some judges who hate would not be the word, who do not like to appoint children's counsel, and we have a group in the middle. So some of them really will appoint often, they find it very helpful, others don't find it helpful. So Fett's decision, which I won't go through the whole thing, but he really said, you really have to assess why. Why am I appointing children's counsel? Is this child in a situation where they can express things? What's the nature of the information? Like, is there a specific role for children's counsel? And are we just doing it to hear? Or is there an issue? Often you'll have cases where it may be academic issues where parents are fighting over, does this child go to this school, or does this child go to this program, or does this child get special needs? Sometimes I've had cases where I've been appointed just to help out with that particular issue. So all kinds of extra factors I'm just going to skip through this a little bit. And so he wanted to have, he was of a position that even a 12-year-old child should have counsel on that particular matter. So lots of us got our backs up as a result of that. 11 he felt was too young. So really, when you're asking for children's counsel, again, you guys are coming on these after the order is made, when the appointment is made. But when you're asking for parents, you really have to think about why you want children's counsel out there. Exit convention says they should have a right to have counsel, but there's also case law in Alberta says just because the Divorce Act is in and views and preferences are there, doesn't mean we have to appoint on everyone. At Legal Aid Alberta, for us to appoint on the high conflict stuff, so it has to be deemed by the court to be high conflict. So not every child, the court has to make an assessment that it's high conflict. And a lot of people like, that's not really fair either. Does it have to get to that point where it's high conflict before you get their voice in? Would it not be better to have it much earlier? We're going through all kinds of changes with our family law process in the higher court right now. So it's a time of lots of transition, and people have to go to mandatory ADR before they can get into the court process. So there's lots of people saying, why aren't we appointing counsel much earlier? It's a priority area for the staff office. So Legal Aid Alberta has staff offices in Edmonton, Calgary, Red Deer, and in Lethbridge. So we have a team of lawyers in those offices, not every lawyer, but a team of lawyers that do that work. So the files will come to us first to see if we can take it. We may not be able to because of capacity or because of conflicts. When it goes out, counsel don't get to choose which lawyer they want. It's up to us to decide who counsel is appointed on it. And it only goes out to one of our lawyers on our roster if we have a conflict and we can service a geographic location. In Yukon, as I understand it, and please correct me if I'm wrong, counsel determines what role they're going to take. Public guardian doesn't tell you what role. You meet with the child. Where the child is capable of providing instructions, then the direct advocate of a child's instructions to communicate to the court, just like you would an adult client. You have a sister-client relationship, you're going to be a direct advocate. The guidelines provide help on determining a child's ability to give instructions. If incapable of providing instructions, the child's role is similar to a friend in the court, which I'm assuming there is more of an amicus type arrangement. They must ensure that the child's views, sorry, I'm moving my things here. You must ensure that the child's views, wishes, and all relevant evidence relating to the best interests is before the court. You have guidelines which explore what's the basis. Has everybody in the room seen the guidelines and are familiar with them? Okay, so I won't spend too much time on this if everybody knows about it. You have to explore what's behind the preference, not just, oh, the kid told me this. Why? Why do you want this? Why do you want that? What makes you feel like that's the best way to do things? And assess if there's pressure or influence. As children's counsel, you should not be determining whether there's alienation. That's up for an expert. You can say, I'm seeing some of the red flags of alienation, but you're not the decision maker. Whether that's only up to the court. Because again, as you were saying, sometimes you have counsel that may say, I think this is a case of alienation. I might say I see some red flags of influence or coaching, that sort of thing. And where the lawyer feels that the basis for the preference is contrary to the child's best interest, but the child can instruct, they must follow the instructions. If the difference between the instructions and the best interests are so great that the lawyer may have to withdraw. So I'm not quite getting that one, so maybe somebody can explain that. So rather than taking on a best interest role and saying, my child wants this, but I think this is the best thing for them, you're not able to do that. You're not able to be an amicus. So you withdraw from the case, you just say what the child wants, and I think might be the best for them is, how do you kind of deal with that and explain that? Megan or Megan's mom, whichever.
Yeah, I'll take a stab at it. I think it's, the one that were the only one I had was, where I knew that the child was being so influenced by the mom, by the parent. The judge had asked us if I would go and interview the two children over at lunch at school. And I said, sure, I will. And by the time I got there, mom had already got there. And they just blurted out what she had told them. And there was no way that I was going to be able to change that. They were old enough to give me instructions, but I couldn't take those instructions. So I just went back and told the judge that I couldn't have it.
Could you, we'll talk about this in a second, we talk about roles. Can you in UConn take on an amicus role?
I think I could have. I wasn't prepared to.
Okay, fair enough. Yeah.
I may have said too much. It's an amicus. Yeah, I think we can do that. I haven't done that. I've ever taken that on.
Okay, good. Well, thank you for that explanation. So in Alberta, when I was with the Office of the Children's Lawyer in Ontario, there wasn't this big discussion of you put views and preferences of the child before the court, but you gave the context. What's behind those views and preferences and what's making the child say what they want to say. When I got to Alberta, there was all this discussion on role of counsel, being either a direct advocate, in which their interest in the title wasn't even around then, an amicus, or a best. A lot of the lawyers were doing the guardian ad litem, best interest. So they'd meet with the child, they'd hear what the child say. They wouldn't necessarily tell the court what the child said, but they just say, this is what I think should happen. And the courts really don't want that. They don't want it in Alberta. They want they're the decision maker and what's in the child's best interest. They do not want counsel telling them. Again, you're always making arguments on best interest of all the factors, but you can't be the decision maker. So the various roles, direct advocacy, except by any legislation or practice, assumes full competence. You act on instructions. There's that solicitor-client privilege. So just like an adult, you have solicitor-client privilege. There are some exceptions, and we'll talk about that when we meet with the kids. There's no set age. You can still advise and negotiate and give counsel. So as an best interest is to discover and promote the best interest decisions. With an amicus, there's no solicitor-client relationship. So you can share everything. You can put evidence before the court that may not be what the child wants and may not be, they may want to live with mom, but mom is a heroin addict and she can't look after the kids, or she's done this, or she's done various things. You can put that evidence before the court. The interest in entitlement is a newer one, and that was set up by LRCY, the Child Needs Advocates Office. And just as Anna Laparco, she was counsel for them that when she was at Denton's at the time, and she worked on a paper, which I can provide to people on that. Took me a while to get near to agree with it, sort of thing. And there's an amicus role when you've got those alienation cases. And but my position is, regardless of what role you're taking, you always advise the court what the child's is. You're there to share what you can. You may or may not agree with it, but the court should always know. So direct advocate, at one point in time in Alberta, we had guidelines for representing children as part of our code of conduct, but those guidelines came down because not everybody agreed upon them, so they're not in place now. So if you're a direct advocate, you put the instructions of your client before the court and the evidence, and only evidence that supports the client's instructions. The duty of making a decision as to what's in a child's best interest lies with the court and not with you. You must meet with the child and then advocate their views and preferences as you would an adult client, and there's that solicitor-client relationship. And that duty of loyalty, that's the bigger one. Is if you have a duty of loyalty to your client under the code, you can't breach that duty of loyalty. So about 5 years ago, maybe it's 6 now, LRCY developed a new role, which in some ways is kind of similar to the Office of the Children's Lawyer, where you put views and preferences, but you put their interest behind it. So if a child is able to instruct, they must instruct, and they must be a direct advocate. If the child does not have that ability, then the appointed lawyer is to fully examine the child's interests and entitlements, looking at your convention, what are their interests, what are their entitlements, and present evidence and act in accordance with the position that honors the most favorable outcome for the child. Nonetheless, bound by solicitor-client privilege unless there's harm, and Justice Loparco and her decision, and that's one decision out of Ontario, really long, but it is well worth reading, and I think I've already sent Annette and Megan the link to it, and she discusses the role of counsel. The decision itself is interesting, but it's the appendix to the decision that are probably the most valuable. And she discusses this role in detail. Interest and entitlement is where a child cannot articulate a view of preference or viewpoint, and this role of counsel is to be able to objectively explore all the interests and entitlements of the child, including but not limited to their physical security, their safety, their emotional well-being, education, health, religion, all those things. You're going to put information before the court. The King's Bench justices, particularly Justice Parker, now that she's head of the family department, really wants this role to be taken if you have a child who cannot instruct. Amicus curiae, and again, that's more of a friend of the court. We used to have where we just have orders where the court would say right off the bat, I want an amicus, or it used to be that we could self-appoint. You could have an order appointing you, but you as counsel made the decision you wanted to be an amicus. And I've done lots of files where I've been an amicus versus a direct advocate for kids. So in that, you're to maintain your neutrality. You should be maintaining your neutrality regardless of what role you are taking. You want to come in? There's seats.
Yeah. Just trying to find one.
I think there's one right.
No, there's this one.
There's extra chairs. There's extra chairs up here. You can have this chair too.
Oh, thank you. Sorry, I'm passing it.
I may have spread stuff everywhere, but.
Try to do something. You're sitting next to your wife. Common law.
Sorry, for stepping away.
Thank you.
No problem. Nothing embarrassing you. So back to the amicus role. So an amicus, you're a friend of the court. Sometimes the court will appoint you directly. You have no obligation to advise the child's wishes. I generally do regardless. If I'm an amicus, I'll say this is what my child wants. You're not the role to act for the child. You take instructions from the court, not from the child, and you assist the court in decision making. And it's where the child lacks capacity or refuses to instruct, or there are serious concerns regarding alienation, undue influence, that sort of thing. So in our court order that you'll see at paragraph number 4, we have a provision that if there is reason, so the order says you got to be instructional or interest and entitlement. At paragraph 4, it took a lot of convincing to get Justice Parker to agree with me on this. If there's reason that counsel to be concerned about the sincerity of the child's instructions, such as the belief that the child is being subjected to coaching, duress, or parental alienation, they shall advise the court and it may determine whether or not to relieve counsel of their duties or to appoint a meeting amicus. So you no longer can self-appoint, you have to bring it back to the court, say, these are the concerns that I'm seeing, these are the red flags, and then the court can determine whether or not you can be an amicus. So as an amicus, you're going to help the court in various ways. You're going to arrange for the investigation of facts, usually by professionals. So you may be hiring, in Alberta, we have a whole bunch of practice directions on family law matters. Practice Note 7 has various ways you can get parent expert evidence before the court, such as a triage report. What's often used by Children's Counsel is a voice of the child report, where you retain a professional, usually a psychologist, who will meet with the child. They'll do what is called an evaluative voice of the child report, where as Children's Counsel, we can do a non-evaluative, but they can actually do some testing, or they can look at it from a perspective as to whether or not they see any red flags there. You help provide the evidence before the court. You have a question?
It seems to me, maybe I got this wrong, but you're saying a lawyer would start out as counsel appointed for the child.
Yeah.
Then under certain circumstances, they may shift from taking instructions and executing those instructions to providing more of a kind of their own opinion or.
That's more the best interest role, which we'll talk about in a bit. Yeah.
And then if there are these other concerns, that the appointed counsel then, according to the template order, would move into an amicus role.
With the court's permission.
With the court's permission, but doesn't that create a sort of an untenable conflict of interest, where you're in a solicitor-client relationship with the child, and then suddenly you're asked to be basically the court's lawyer with no confidentiality with the child? Usually
in the cases where I've done it, it's usually early on, and it's usually those children who are either can't articulate. So when I talked about where there's two parents that were not criminally responsible, where you've got a child who can't articulate, or the evidence that, and usually you're not necessarily making the decision. You're not making the decision on the alienation. You're saying there's some red flags, and usually it's those cases where the pleadings are such that everybody's raising alienation. And you may, and I tend to, if I'm going to move from that, I'll move from it very quickly. Before I'll have a meeting with the child and assess the situation and hear what I'm saying. But again, it's only up, I can't self-appoint anymore. And it's only up to the court to decide whether or not they're going to let you move into that role. If they say no, they may say, okay, a new counsel can take on. And often that will happen and it may be that that the lawyer who's coming off the file may say, I think it may be appropriate for the next counsel to come on to take an amicus role. So, but generally I find the courts, they're just so happy to have somebody else to help. And they know if I say I need to be an amicus, generally they'll take that. And they already know. Often there's 10 EPOs and there's this and there's that happening, and they've been through every professional. They're generally okay with being amicus. You still put the child's views and preferences before the court, but you also make sure all the evidence is there so the court, because parents, particularly if you have self-represented individuals, they're not even going to know what necessarily the evidence that they need before the court, and the court needs to know some of that stuff. So you're right, it's that breaching that duty of loyalty. So, and these are to be done in extraordinary circumstances. It's not every case has some influence or some coaching happening, but it's got to be significant. So the court this will rarely happen now. This will rarely happen. It will be extraordinary. And it will be up to the court to make the decision as to whether or not that same counsel can stay on. So doesn't happen often anymore. It's really under regulated circumstances. But you're right. It's if you've built that relationship. But at the same time, you don't want to have kids, because of the alienation or coaching, not to have counsel. And John Martinson has written yet another paper on that. It's like, it's not fair to say, even if there is alienation, even if there is influence, that those kids shouldn't still have some representation and their views and preferences before the court. Because other thing would be either, and when they did the training back in 2005, Justice Tressler, who was a very powerful lady, was like, I don't want mouthpieces. I don't want Children's Counsel to just be mouthpieces. So at that point in time, they were more even onto a best interest. They wanted Children's Counsel to be saying, this is what I think should happen. And they'll still even today push you. What do you think should happen here? And then you're caught. It's like, This is what my client's instructions are. So you have to be very careful. You don't want to insult the justice, but at the same time, if you're in a direct advocacy role, that's the role you have to take. It's tricky. They're not easy issues.
Sort of budget, and, you know, we'll all just kind of, you know, disregard our fundamental professional ethics.
Or you can
for the
ask to
benefit
withdraw.
of the process, which is important, I get that, but.
Or you can ask to withdraw. You can bring it back to the court and say, there's this, as you did in your case, there's concerns here. I think I need to withdraw because of my duty to loyalty to my client. There can be separate counsel appointed for the child, and it may be beneficial for them to be appointed in this particular role. So you're there right off the bat.
I do have another question in that regard. The system that exists in Ontario does allow the parties to challenge the report by calling for a settlement conference under the rules within 31 days of the report being provided. The court will set it into a settlement conference, and usually during the conference, the court is looking at the very nature of the report and the allegations made against possibly mostly the clinicians. The lawyers are usually very professional in the way they approach it, and the court might request particular investigations as it relates to further investigations that could also still take place. And then to what he did say, I've had a situation in Ontario where it was not, a clinician was appointed by the Office of the Children's Lawyer. And in that situation, it was without a court order. We didn't even know that was ongoing. The clinician attended several meetings with the lawyer who had requested help for the appointment of the clinician. Apparently they can. When
The children's lawyer, just want to make sure, it was the children's lawyer who asked for the social work assist?
Yes.
Yep.
So
Which
she
they can.
came, sat through the entire conversations, and they provided a clinical report and an affidavit in support of it. In that situation, the dad had appointed a private assessor to counter some of the presentations that has been made, only to get a trial. We found out that the clinician was involved, did an affidavit, also attended the trial, and eventually that was the basis for the court decision. In hindsight, I'm just letting you know about it, that the court will need to approve that, right? For in a situation where a clinician or a psychologist is involved, that will require.
No, not necessarily. In Alberta, I can be counsel for the child and I can meet with my child. And if I think it's going to go to a trial, or if I think there's need for an evaluative voice of the child report, I can retain. It would be under, I'd have to go back to the court and say, I want a voice of the child. And if you want the protection of a PN 7, practice note 7 order, then the court does do an order for that. So, but it's me saying, I think I need evidence here. I want a PN 7. I want to get a voice of the child report. And I'm as counsel saying, I want to have an expert, analyze the situation because I've got concerns for various things. Rarely will they say no. The bigger problem is who's going to pay for it and how much they are.
I can speak to that.
Oh, yeah, please
Under the legislation where I have the authority to appoint a child lawyer, I also have the authority to appoint any other expert that might be necessary.
Great.
Necessary, appropriate. However, the current child lawyer guidelines are very specific to me appointing the lawyers. There's a bit of a disconnect between the guidelines, which are the policy that we follow, and the legislation, which actually does provide the authority to appoint other.
So do counsel then need to ask the court to make an order to assist them in getting the public radio?
It's honestly never come up in my experience.
Okay, we'll see where it goes from here.
I also. I'm looking castle too.
Like, have you had assessments done as children's counsel?
Oh, yeah, something else. Well, that's the guidelines.
Yeah.
Yes, yeah.
No, so our practice is under the Children's Law Act. The expert who's appointed is a child lawyer. And then
Otherwise, what is done is we obtain from the court a recommendation for a
And
missing access report to be done.
Okay.
And then that recommendation is sent to the Director of Family and Children's Services. So
In the high conflict stuff and the parenting stuff, or is that just under the child welfare?
The missing access report is within that is to obtain the views of the children as well. It's just a different professional, a different lens that it's looked at. But that's really interesting.
Extraordinary, yeah.
So that would come from the PGT budget then, theoretically.
Yes,
Yeah.
theoretically, under those two sections of the central legislation, yeah.
And that kind of comes back to that whole issue of Strobridge, whereas counsel, you can put information before the court, but if you're going to a hearing or a trial, you're not going to get up on the stand and give, believe you me, they've tried it in Alberta as well. Tried to get, oh, I want the lawyer to now testify as to where they came from. Like, no, our order says we're definitely not a witness, sort of thing. We also have a provision in our order, which protects us a bit as well. We have a provision in the order, paragraph number 11, which says, child's counsel shall be permitted to provide a summary to this honorable court of the information acquired in the course of the children's meetings, of the meetings with the children, and shall not include any discussions of issues relating to the proceed. Sorry, I'm reading 2 paragraphs here. So children's counsel shall provide a summary to the court of the information acquired during the role, subject to the protection of confidentiality and privilege. So if my child client says, don't tell anybody this, I don't. And by doing so, they shall not be deemed to be a witness in this proceedings. So that provides us. So we may do that. We may do a report, but again, it's non-evaluative. It is just, you're not evaluating, you're not making determinations. If you want that evaluative piece, that's where we would retain a parenting expert.
Yeah. And I think it's to Kathy, like, we have a more succinct way of articulating it, but here in the Yukon, there's a very clear understanding of what the role of the child lawyer is. And what is not in that role is tendering evidence. So we're there to tender, to provide the views and preferences of the child to the extent that they provide us with those instructions or the best interest principles, which I didn't get into. So this clause under the public guardian trustee would allow potentially to retain some other expert. My guess is that it would be the parties who would potentially be applying for it and not us as the child lawyer who would be seeking that done, because then what would we be doing with that expert report? That's not necessarily.
We would call, if it were going to a trial, and it sounds like more things go to trials in Alberta, we would be calling that expert as our witness. And we would be leading them through their evidence, and the parties would have the opportunity to cross-examine. So that kind of goes to the issue of when you have children's counsel who's providing information, how do you challenge that? So you're not going to get to counsel on the stand, but if there is that, if you have a parenting expert, you have that opportunity.
Because if you're really child lawyer, child advocate, then you should be able to challenge any of the parties. Challenge the ability of any of the parties to the litigation. I mean, you can't do that without the expert, like with custody and access report, because with the custody and access reports that we used to have many years ago, with using psychologists, they interview the parties, they can make psychological assessments on the parties and their ability. Without that, your hands are chopped off. You as child lawyer want to challenge the suitability of the party to them.
That it seems there is a major role in the Yukon. In Ontario, when there is a voice of the child reporter, it's always a lawyer. It's a compellable witness to testify at a trial. When the child's lawyer is appointed to advocate for the child, that's a separate role. You cannot compel them. You cannot receive the sources of the information or the record. Then, if a clinician is a social worker or is also appointed, we always receive their notes, their sources of information.
And they testify.
And when they testify, you can cross-examine them, you can impeach their statements in court with the record. So there's a matter of rules here, and it raises a bit of conflict in the surface. But
so as you think about ideas and challenges, what works and what doesn't work. Think about it as you look at changing your guidelines or keeping your guidelines or enhancing your guidelines. One of the other roles that used to be taken a lot with that best interest role, and that's where counsel subjectively meets with the child regardless if they want, says what their position is. Courts really don't want that anymore. They're the decision makers, they're deciding. How do you determine what role to take? As counsel, you make that decision. If you're going to want to do an amicus, you have to provide the information to the court, but it's you, after meeting with your child and assessing their ability to instruct, their capacity, you make that decision. Again, it used to be that we had to look at a reporting role because you'd often get files where the court already decided you were an amicus, or court had already decided, or usually counsel, not the court, had decided for a 4-year-old you're going to be an advocate, sort of thing, where it might be something different. So again, look at the capacity, and we'll talk more about that later on today. Qualifications, I've taken a set of your guidelines. So here, training in ADR, understanding of the various issues that face the child, such as alcohol, drug dependency, domestic violence, emotional and psychological abuse, understanding child development, which I think everybody needs to do that too, understanding FASD and ADHD, experience in interviewing children, good understanding of children's lawyer matters and court process, and experience in family law. In Alberta, our legal aid standards are you must have minimum 5 years of practicing family law. So you're not getting people dabbling in this who don't have a good understanding of family law, and you have to have understanding of child development and understanding of the brain science. I don't know if anybody's familiar with the Alberta Wellness Institute has a whole brain science course that you can take, and it's there before parents can go through any sort of family law proceedings. They have to take the parenting after separation course, which I think you have something similar here, but that has a component on the brain science. I would strongly suggest it's a free course. It's funded by the Palix Institution in Foundation in Calgary. Really good. So understanding the impact of the toxic stress on kids is really important for people who are representing kids. You have to experience working with children. You have to attend training. And I cannot tell you enough how important that is, that people attend training on this is some. There's lots out there. Attend as much as you can. You learn something every time you do one of these. And we also have requirements for all of our lawyers on our panel must do a minimum of 8 hours per year of continuing legal education in the area of child representation. So not just family law in general, but specifically to child representation. We also have our competencies. They have to have knowledge of the family law legislation and any amendments, and know how to run a file. They also have to have specific training and experience in representing children, know the convention, know the practice notes, all the things that go with representing children. They have to have experience working and interviewing kids, and strong problem solving, conflict management, resolution focused, negotiation skills, similar to you guys, and some of them are collaborative lawyers as well. So again, Children's Counsel, part of the solution, not part of the problem. We want to be helping people resolve where you can. And LRCY, which does the child welfare side of things. You have to be this is from their website. They have to be an active member of the Law Society, be willing to provide representation in accordance with the guidelines. So LRCY guidelines say you've got to be a direct advocate. You've got to be if not a direct advocate, you have to do the interest and entitlement role. You can never be an amicus. They have panel interviews. You have to provide, we do as well. You have to have a record check, vulnerable sector check, child intervention check. You have to sign a roster agreement, and they have mandatory training. They actually have some training coming up in June in Edmonton at the River Cree. Every year, every other year they do. Every other year they do an LRCY conference, really worth attending if people are able to do so. It's in Edmonton this year. They have guidelines on how often, because Legal Aid Alberta, because some of our staff lawyers and some of them are private roster lawyers, we don't tell them how they are to run a file, so we don't do that sort of file management piece. LRCY has some pretty firm guidelines. They have to have a minimum of 1 face-to-face contact with each child wherever they're living. They have to meet with the child in a location that's most comfortable to the child. I find vast majority of them, they're on files where the kids, they don't necessarily appoint if it's a situation for a supervision order. So if a child is remaining in a home with a parent, they don't necessarily appoint on those. They do more for TGOs and with kids in care. So they spend a lot of their time meeting with kids at foster homes. They gather information, provide high quality representation. They must attend all initial custody hearings and other hearings of substance. When you get tons of lawyers on a file, it's really hard to make sure that everybody's there to make the submissions they need to, and they have to take that instructional advocacy role. Okay, that's it for the morning. So the first part of the morning, we are going to spend the rest of the morning, take a break. We're going to have the role play. We're going to have some more about meeting with children. Hey. Okay, so we're going to talk now, before we do the role play, about meeting with children. So, as your role of lawyer, what is it your job to do? It's to help address the child's fears and anxieties when you're meeting with them. They're going to come in, they're going to be scared, they're going to be nervous. You're going to explain to them this is a safe place to talk. You're going to answer their questions. Some kids will come in, they won't want to talk at all. Some kids will come in with so many questions and so many things they want to know and why. You're going to explain the process, court process. Most lawyers don't understand it. Certainly children don't understand it, and then explain in child. You're not going to tell them about every affidavit. As I said, you're not going to read stuff to them. You're generally going to explain, why they're coming to see a lawyer. Moms and dads having some difficulties. Sometimes judges want to hear what kids up to. So you're going to obtain their voice, not your interpretation. So not doing that best interest role, saying this may be what they want, but this is what should happen, sort of thing. We're not a psychologist. I know I certainly am not a registered psychologist in any way, shape, or form. I'm not here for counseling. I can't counsel them. I can give legal counsel, but I can't counsel them on all of the other issues that they're happening. And any report that I write or any summary report that I do is non-evaluative. I'm not here to analyze whether or not this is alienation or this child is ADHD or this child has psychiatric issues. That's not my role. That's not my expertise. We're here to give a child an opportunity to be heard and express their views and preferences in a safe place, in a child-friendly, safe place, and ensure that their voice is heard. So if you're going to do this work, number one, you have to like kids. If you don't like kids, this is not the place. Thinking, I might want to be a parent someday. Not the place to do it. Does it help if you have experience with kids and have your own kids? For sure, it's great. As I learn new skills, and I have a set of twins, Oliver and Olivia. They are just both graduating from university. So as I work through this, various experiments I would do, they're like, oh gosh, she's trying your child rep stuff on sort of thing. It's helpful to kind of get some skills of dealing with teenagers and that sort of thing. You have to be willing to engage with the kids at their level and know the ages and stages of development. I sent God love for Annette on Friday afternoon, all kinds of materials. So if I talk about papers or I talk about ages, stage of developments and materials that are out there, copies of all that. We haven't printed everything. Again, remember I said I'm not a friend to trees, but I didn't print everything and didn't take it with us. But some of the ages and stages, is Piaget has it, Pruitt has a good one, ages and stages and red flags of what might be something that's extraordinary, what's different. Some of the best training that I have done over the years is with Lori Asnick and Jonathan Grant, and they have a whole program. See what that's on this. So, they have a whole program that they do, and I did it online during COVID. Some of the best. They're psychologists, so they're not lawyers, so it's a bit different, but it's getting kids to talk and engage. And in part of their book is sort of ages and stages of kids and really good section. So if I'm going to meet with an 8-year-old, I might go back to my book and read, okay, just make sure I'm kind of teenagers, that sort of thing. Go back and look, what can I expect? What might be odd? What might be odd in their language? You have to really listen to kids. You can tell if they're talking themselves or if they're kind of repeating things from. I had one little girl who was 8 years old came in, and first thing she said to me, I'm on Lisa's side. Lisa was the stepmother. Side of what? Well, the court fight. I'm on her side. She came to my office, and so Lisa had a great opportunity to tell this child for the whole way in for an hour all the things she had to tell me. Did I meet with that child in my office again? I've gone to different locations all the time. At times, often when they don't know I'm coming, I'll go to the school or I'll have meetings. So there's not that opportunity to prepare the child. So she had no idea why she was on anybody's side, but she was on that side. So you have to be able with younger kids, and again, you may not have as many files with younger kids, but if you do, you got to be willing to get down on the floor and play with them, get them to engage. different ages and stages, how you're going to deal differently with kids. You have to be sensitive to their needs and see things from their point of view. What you may think should happen and what they think may be very, very different, but you think from their perspective and what they've experienced and what they're thinking. You have to be prompt and responses. You know, we all get clients that email us. Kids, I find, don't even email anymore. They're a text sort of thing. I generally don't have kids contact me a ton. If they do, I usually try to get back to them really quickly because there's usually something urgent. And if you get a parent saying it's really urgent, the parent's sense of urgency and the child's sense of urgency can be very different. Sometimes waiting the next day, whatever the issue was. But if I have issues with the child harming or certain infinite domestic violence, I'll get back to them really quickly. Make time for appointments and do it on their schedule. And when I say that, it's like, I generally, as a practice, try not to take kids out of school. I think school is really important. So I might meet with kids later in the day, after school, or maybe in an evening. I personally do not go to the children's homes in any way, shape, or form. We talk about being a witness. You don't want to be in a situation there. You're not there to analyze the homes. You're not a social worker. You're not doing a home study. I try to meet with them either in my office where we have child-friendly rooms and activities, or I often will meet sometimes at the school. I find the school can be the most neutral place to go meet. Generally, the schools are pretty helpful, particularly if you have a court order that says you can do it. And you don't get kids that are prepped. I don't necessarily let parents know when I'm going to meet with kids. And I also have that little girl who I often will meet at a mall, has her other parent who can't bring her, doesn't drive. We meet at a mall in that area. We have a little location, we have a little snack, and we chat and we get some privacy, and it works out really well. So, but do it when it works for kids. I generally really try PD days, things like that, try not to take them out of school. So be able to give enough and appropriate type of support so that the child feels their issues have been addressed and they feel that they've been heard. You also, if you're going to be children's counsel work, you're not going to be their counselor, you're not going to be their psychologist, but you sure should have a good idea of what are the resources that are available for kids in your area. Who are the good psychologists? Who are the good counselors? Not that you're necessarily choosing them, but the court may ask you for recommendations. The court may ask you for what might be some of the things that they need. You need to know if you have low-income individuals, where there may be counseling services that may be available at different rates of pay and things like that. Why meet with a child? For the lawyer's perspective, it's an opportunity to hear directly from the child. You know, when a child's views shouldn't come from what mom said or dad said, it should come directly from the child. So you hear their views and preferences. It's interesting, I was at a session 2 weeks ago, and Lori Asney was doing, she said she wished, it was the first time I really heard this, she said she really wishes the legislation hadn't used the term preferences. Views is one thing, but preferences, the minute you put that word preferences in it, kind of makes kids sort of feel like they have to make choices. It's an opportunity when you meet with a child to assess their capacity. What is the capacity of this child to understand we'll come back and talk about capacity in a minute, their own needs and their interests. It's an opportunity to obtain instructions directly from the little horse's mouth, as we should say. For the child, it gives them an opportunity to ask questions. It gives them an opportunity to express their views and preferences in a safe environment and it's part of your job to make sure it is a safe environment. It's part of your job to ensure that the child has privacy. I'm a bit old-fashioned. I really prefer my meetings with my kids to be face-to-face so I control the environment. I know where people are. If you have, I think COVID really forced me in particular, to think outside of the box when you couldn't meet with kids and you had to do some virtual meetings. And I'm sure if you have children from all across Yukon, you've got lots of issues where parents can't bring them to your office and things like that. You need to do things virtually, but still, you have to ensure that you've got privacy, they've got the ability to speak, and there aren't other people outside of the screen. One of the things that we'll often do is with kids is we have a contract that we ask parents to sign that talks about sort of the rules of video meetings and give the child privacy. And if there's a blurred background or there's I don't know what you call them, the background you have, if it's not the room or something like that, then that's kind of a red flag to you. Let's see, sort of thing. We like to say, oh, show me your room, whether the phone or whatever, then you can kind of see who all's in the room and gives them an opportunity to talk. And it's an opportunity for them to be heard, to provide input, but not to choose. So really, I would strongly suggest, and what I say today is not you have to do this in any way, shape, or form. This is just an opportunity to provide some thoughts. For people, take what you want, don't take what you want, do whatever you want with it, but this is just how I do mine. But I always talk to kids about just because you have a lawyer doesn't mean you have to choose between your mom and your dad, and doesn't mean you're the decision maker. So that just in and of itself will take some stress off kids. Because if they think they have a lawyer and they now have to choose, it makes it so hard for them. So how do I prepare for the meeting? Meeting with a client, chances are an adult client, you're going to read whatever pleadings may be there, you're going to get background. Same thing, you're going to hear me talk to the kids. And the ones we're going to do today are kind of first meetings, so you're going to see how I get information. But first, I like to, and different lawyers have different practices. I like to, one of the first things I do when I get an appointment for children's counsel is I send a letter out to the counsel if they have counsel, if I'm lucky enough to have lawyers on the file, if not directly to the parents, which talks about my role, talks about what I'm going to be doing, sort of thing, and talks about please send me all copies of the pleadings. So I get copies of everything. There may be reports from the court. As I said, we have practice notes in Alberta. Some of those reports are sealed, and I need to get the court to give me those. Parents can't just directly, parents can't have them, number one, but the council can't just send them over. So I get, if I'm on a child welfare matter, I'll also get the disclosure from the director, so I kind of know what's going on in the situation. Sometimes I'll have if there are two counsel on, we'll have a teleconference and say, okay, I've been appointed on this. That's when they will give you whatever background. I really try to be very transparent and very neutral with my work. I don't have private conversations with this lawyer, private conversations with that lawyer. I don't have emails with this lawyer and emails with that. Everybody gets everything. And I tell parents, there is, and counsel know it, but parents know it, there's no confidentiality in what you send to me. So whatever you're sending to me, you better be CCing the other side, and you better be CCing the other parent if yourself out. Because they think, oh, and I always say, you're welcome to provide me information, but whatever you provide is going to go to the other party. So be really careful with that. And I'm even really particular about when I'm in court where I sit. And I know it drives me crazy when I'm on for parents and director's counsel is and the children's lawyer sitting right beside them and they're chatting. And I know what's going on and I know that everybody works together. But parents, they don't know the relationships that are there. So you may be best buddies with the next person, but you sure should look apparent and you should look unbiased and you should look fair. So I try to, when we have a courtroom, I'm usually the one either in the middle between two counsel. I try not to sit on one side or the other because that sends messages, or I'm off on the side somewhere, sort of thing. Some counsel will have meetings and phone conversations with parents. I generally don't do that as my practice, and I don't do it for a number of reasons. I think once you've learned a few times, you sort of learn. If you have self-represented parties, they, roles can blur. They think you're their counsel. They think anything you put in writing is God honest truth, or that's evidence of what. I had one trial where a guy put in every letter they'd ever written as to what the child's views and preferences. This is what happened, sort of thing. I'm really careful. What I will do is after I've met with the child a number of times, and if time permits, sometimes you get appointments on the eve of court and you don't have the opportunity to do that. I like to sit everybody down, be it mom, dad, mom's lawyer, dad's lawyer, whoever, whatever it is, and have what I call the disclosure meeting or a settlement meeting where I'll share, okay, this is what what I'm allowed to share. And we'll talk more about that. What I'm allowed to share, I'll share it so everybody hears everything at the same time. So you're not having side conversations with people. Oh, she told me this, she told me that. Everybody's hearing the same thing at the same time. If you get the pleadings, then you can kind of hear your questions or what your discussion is going to be. Then you're kind of going to know what the issues are. What are the issues? Is education an issue here? Is it abuse is an issue? Is it domestic violence? Is there sexual abuse allegations? I kind of want to know some of that stuff before I meet with a child, because I don't want to talk about things, or I don't want to phrase things and such that it's going to cause any harm to them. Remember, kids are not little adults. They're different. Their ability to remember things. They have difficulty understanding questions, recalling information, dates, etc. Like they're not, if you say on such and such a date did this and this and this happen, they're not going to know the date. They tell you about something with what grade were you in. That's more of a reference point to them than the date. Was it summer? Was it winter? That sort of thing. Do things such that it's easier for kids. And they can't always distinguish between realities and perceptions. And again, I go back to the child who was 2 months old when there was an incident of domestic violence. That child doesn't remember any of that. It's what they've been told, and that becomes their reality. Learn how to speak, and you'll hear me say this so many times, learn how to speak to kids at different ages and stages of development. How you talk to a teenager, very different than how do you talk to a 5 or a 10-year-old or a 12-year-old. One of my friends that does his work says he mirrors how the child talks. So teenage, you might get a little cursing in there back and forth. You want to build a rapport with a child. I'm not saying do that every time, but it depends on the child. Understand the age and development level, get informed on child development, read the materials that we will send out on ages and stages of development so you understand that. And be alert. One of them, the Clue-It materials are really good on red flags. If you hear these things, if you see these behaviors, these are some red flags that you need to look at. Assess what's the language. So the child uses, like if you have a child coming in saying, I need an obsessive occupation of the house. No, maybe there's something going on here. I'm on so-and-so's side the first time. Your little red flags are going up. What's the child's ability to recall and understand based on their age? Is this something that they're aware of? Is this something we've heard about numerous times? Explore that a bit. And what tools you're going to have. After doing the meeting with children, I use a lot of different tools, particularly at my first meetings with kids. And I cannot, and I'll say this a number of times today, I cannot strongly suggest enough for people, get training on child representation. Continue to get training on child representation. Your skills just get enhanced over the years. It's going to cost you some money, but it's an investment in yourself. It's an investment in the children you're going to represent in the future. So with the Meeting with Children program, they can give me permission to show everything, but they have their cards, they have different things, tools that you use to get kids to talk. One of the things that I often will do, particularly at the first meeting, is a bit of a geneogram where I'll have a child sit down and we'll have a big piece of paper, and they use a lot of symbols and things. They have different characters, and we'll write out who's on the family. I'll do it today verbally, rather than like, who's on your family, mom? Which character might look like this? And then who else is there? And then how do they get along? You know, a straight line for really good, not so good, really bad. And you kind of get a sense of the dynamics, who's important, who's involved with this child. So I have lots of tools. And I even have my magic wand here, which I will often bring for younger children. And this is where they do their 3 wishes. And that's one of the things I would do. If you could have 3 wishes about anything in the world, what would they be? Girls will have certain ones. Boys will be video games, Lego. And I want this. Okay, now let's change the game a little bit. 3 wishes about your family. If you can make any changes, 3 wishes. Sometimes it's wish mom and dad will get back together. Sometimes it's, I'm so glad they're not back together. I never would live in that. Just different ways of getting cards. Sometimes will play cards. I always have paper there. Kids, when they're talking about their family stuff, it's not easy for them. Sometimes having something to just keep their hands occupied or just to color when they're distracted a bit. You just have to get a child to open up. So it's building that rapport. So you're going to have different stages with your meeting with kids. You're going to explain the process. You make them feel comfortable, and that's really important, and build rapport. That may be, if you want to have a good relationship with your child, you want to get good information with the child, you need to spend the time building rapport. It's not you bring them in and here's your list of questions. Oh, you may see a little bit, but sort of thing. You're going to question, you can ask about things, but you're not going to do leading questions. Tell me where you want to live. That's not what you're going to do. You want to live with your dad, right? You hate your father. You're not going to do that. You're going to open questions so kids can give you. You're going to review with them. Okay, we talked about a lot of things today. What can I share? What can I not share? And then you're going to close. You're going to say, okay, this is what's going to happen with this information. This is what I'm going to do with it. This is when I'm going to see you again. Some children's counsel think they have to meet with kids on a really frequent basis. I don't. I generally meet with them before court proceedings or whatever's happening. But remember, every time you're meeting with a child, particularly in a child welfare or in a high conflict, every time you meet with them, you're bringing back to them all the memories of things that have happened. It's not easy for them to talk about it. So be really careful. And sometimes all of these things happen at the same time. So explain the process. What does a lawyer do? Some of them have never met a lawyer. They don't even know what a lawyer is. Make it clear you're their lawyer. You're not mom. You're not dad's. Explain to them again, age relevant terms. How you talk to a teenager versus how you talk to a 5-year-old, very different. I use something like mom and dad are having some problems working out. So judge wants to hear what's working for you, what's not, to help you come up with the best plan we can for you. Explain what we're going to do today. I'm going to ask lots of questions. You'll hear me say, I'm really nosy, so I need lots of information. And I'm really old, so I need to take notes. Is it okay? I ask permission to take notes because I really like to write down. Can I make out the notes later? Not necessarily, but I like to make sure I track their language as best I can. Tell the child, this is really important. I ask, what have you been told about coming to see me today? That could be a really interesting question. You can get a lot of information there. So, mom told me I get to come talk to you today and I never have to go see dad again, or I get to choose where I live, or that sort of thing. And kids, if they don't know an answer, they'll often say yes. So talk to the child if you don't know an answer. I may not with the teenagers today because we have less time, but particularly young kids, they don't know an answer. It's okay to say no, I don't know, as opposed to saying yes, because they'll automatically do that, or they may. And if they don't understand the question, say, I don't understand. And if I'm wrong about something, tell me. If I've caught something wrong, you let me know, because kids don't want to question adults and they don't want to say you're wrong. And if you don't want to answer a question, you don't have to. And I usually get the child to promise to tell the truth. Okay. I also have it that child controls the process. And again, today may not be the best role play because we haven't got hours to do this sort of thing. But I let a child know that when they're done, they're done. They don't have to stay if they're done answering questions, or they want to ask any more. If they just want to play, we can do that. And they're able to leave when they want. Again, you may be able to control that a little bit, but when a child's done, you can tell them they're done and they don't want to be asked to talk anymore. And it's okay not to answer a question if they don't want to answer a question. And I'll explain to them solicitor-client privilege. Because remember, my first meeting, I don't know what role I'm going to be taking, so I'm going to explain to them. But always tell them that there are exceptions to solicitor-client privilege in child-appropriate language. Because if there's harm to themselves, or they're going to harm somebody else, or obviously you have obligations under your child welfare legislation that you need to report, and get permission to take notes. And as I say, I tell them I'm old and I can't remember stuff. And that generally makes them laugh. Gain knowledge. Read the pleadings. Some parents, hopefully you'll find out something about the kid from the pleadings. Again, you'll sometimes see all kinds of affidavit wars where there's nothing about, you don't know a thing about the child, what they like, what they don't like. So again, I'm not trying to be sexist, but if it's a kid, the boy who likes soccer, get to know a little bit about soccer. If it's a kid who likes hockey, tell them you're a huge Oilers fan, sort of thing. Build that into it. Have toys, games, activities ready to go. Keep their hands occupied. Keep them chatting. Interview them in a child-friendly environment. Kids, and again, this is my practice. It depends on the child. We have at our office a child-friendly room. So we have a round table, we have all kinds of things in there. We have, for younger kids, things to play with. You got to be careful, not too many toys, because they'll never focus. I had a little autistic boy who had to come down from Peace River, so it's a long drive to get there. He just wanted to play. So we weren't going to, and the sister had limited skills. Again, those are the type of ones where you might do an amicus because they're not in a position to provide you views and preferences. Slow down your speech. Again, having kids come into a boardroom and with a piece of paper and just asking them questions, you're not going to find that child friendly. Slow down your speech. Again, I'm not slowing down my speech here because you're all adults and I have lots to get through, but use simple language. Hear from the child. How do they talk? What's their level? And allow time for the child to answer. Because we all are so, let's move on. You got to give them time to answer questions and don't interrupt. This is what I'm really bad at. Don't interrupt the child. Let them have time. And if you do interrupt them, apologize for doing it. So building rapport is going to be the most important part. And you won't get information from a child until you've built that rapport. Unless you're doing like a strict interview with them, and they may not share with you. It's going to take the time. So build time into your schedule for particularly your first meeting with child clients. This is not going to be a half-an-hour appointment. It's not going to be, I usually build about an hour and a half just to try to build rapport and get some information from kids. And it could be your first meeting, you get nothing. You get nothing by way of views and preferences. You're just building some trust with the kids. Again, have games, toys, activities ready to go. I always start with asking some generic, ask the easy questions. First, tell me, you'll hear me today. Tell me about school, tell me about friends, tell me about this, before you get into the family stuff. The family stuff is a bit more difficult to get to. And kind of go on a funnel. You start really broad. As you get more questions, you get more information, you funnel it down to get to the heart of what we want to get to, sort of thing. So broad, funnel down. Make it clear right off the bat that they're not here to pick a parent. And again, a lot of these comments, I apologize, I do more of the high conflict stuff than I do the child welfare stuff. So you're not here to pick a parent. Sure that they know they're not the decision maker. And I don't know how many times I've said that, and I'll continue to say that. They don't need the pressure to think they're the decision maker. And ensure that the child understands that their views and feelings are about their own life and are very important to the judge and the parents, but they're not and will not have to choose between the parents. And they have a voice, but not a choice. You'll hear that all the time. Some counsel prefer to have all their questions written out, and I kind of did that today for the purposes of role model. BC have a couple of different things happening there. In the Kelowna, they started with a voice of the child reports, where they have very set questions and they do a verbatim from what the child has to say. I prefer to make it a bit more informal. Sometimes I'll have questions written out. Sometimes I'll just go generally from what I want to talk about. Dig and explore, funnel. Act dumb. Pretend like you don't know anything. You don't have to say, oh, I read the 600 pages of materials in your family file. You don't need that. Like, let them tell you what's important to them, sort of thing. And when their story doesn't line up with what's in your affidavit, don't correct and say, oh, that's not how that happened. Don't do that. So it's their perspective of what has happened. Get down and be prepared to get down on the floor if you have to. Do things on their level. Act goofy if you need to, similar. That's where you head curse if you have to. I've taken that for the purposes of today. Teenager meetings are going to be very different. So you have to have a sense of, they may come in and they may not. Different people may, like young boys and teenage boys, may never make eye contact with you, and that's okay. Indigenous children may not make eye contact with you. You have to need to know some of the cultures. You're going to be meeting with children from many different cultures, many different countries, in Edmonton, we have lots of newcomers to Canada. So it's good to get yourself a little bit educated on the culture and know of it. Because at first you kind of think, why is this pretty? And then it's like, oh no. And some of the games, I think teenage boys don't like. Someone likes the games. They like some of the activities. Sometimes they just want to play. So we often have Lego out to help them be able to make comfortable games. So different things. Provide distance for the child. Let them project on something else while they're talking about their family. They may not want to be looking at you. They may just want to be doing something else. I always have paper and crayons out. At any age group. They all want to draw. Sometimes I'll have them draw a picture of their family, who's in their family, and sometimes that is so telling. And there are times where I have put some of the cards and some of the activities we do. I'm not evaluating them, but sometimes they're telltale, and I'll share it with Corey or the parents. This is how they see their family from their perspective. And sometimes when they draw things, it's not really clear to you what it means. But boy, do the family know what it means. Their parents know various things. So sometimes it can be really effective in sending their message. Again, so some things, games, tools, spare cards, these are all different things that we use. Again, you have all this in your PowerPoint. Frame your question. Set up a context. Think about a specific time when this happened. Young kids don't give them yes, no answers. Because don't leave no yes, no answers, because they're going to go more often than not to yes versus a no. Use people's actual names when you're talking about them versus he, she. That's confusing, particularly if you have a couple of moms and a couple of dads, for him, her. Use people's names. That makes it easier, particularly if you have a mom and a stepmom. You don't know what they're calling. Find out what they call people. That can be really telltale as well. They call the other parent by their first name. That can be one of those red flags. When, why, and how are abstract for little kids, so replace with how come. So just think about how you're framing your questions. If a child's answer doesn't seem their own, dig a little bit deeper. How did you find out about that? tell me more about that, and find out, oh, this is because so-and-so's told me to make sure I tell you all this before I get here. And don't suggest an answer in your question. Oh, that must have made you really angry. How did you feel? Use open-end questions. Don't lead. Avoid questions with yes, no. I think a ton of that. Compound questions. What about this? What about that? Make it simple. Make it easy. Again, they're not adults. Watch your body language. Boy, can they tell when you're bored. If you are checking your emails or you're looking at your phone or you're like looking at, they can tell you're bored. You've got to be physically present when you're meeting with kids. Avoid negative questions because you'll get the wrong answer. So didn't you hit your mom? You didn't hit your mom, did you? Like double negatives are going to be really hard for kids. Give the child a chance to think. It's okay to have silence. I know I'm one of those people who can't stand silence, so I fill it with something else. Give the child an opportunity to think, and it's okay if you're just kind of playing during that time. Don't correct them. If it is, you've read something in an affidavit that's something different, or a police report that's something different, don't be challenging them on it. Don't react to their answers like, oh, or roll your eye. Like, don't do stuff like that with kids. Don't lead the kids, don't correct them, don't challenge their point of view. Encourage a free flowing, well, tell me about that. And you're going to hear me say lots of tell me about that sort of questions. Find out what's working for them and what's not working for them. So you have this parenting arrangement. Tell me what works, tell me what doesn't work. If there would be any changes, what might those be? Not saying you'll get them, but what might those be? What do you really like? Like one of my colleagues had a file where a child absolutely hated to go overnight with their dad. And what the real issue wasn't spending time with dad. It was dad shut off the light in his bedroom every night. He normally slept with the light on. Something that simple. Changing and knowing that information and saying, Dad, leave the light on. Kid was fine going around. Simple things that adults may not think about mean something to a kid. And meet the child at their level. Don't talk over them. Sort of thing. Use age-appropriate language, concrete words, concrete terms. View what we've talked about. What can we share? So as I'm taking my notes, I'm trying, if there's something they don't want to have shared, I'm trying to put a star beside it. Sometimes in my notes, I'll have the V and the P beside it, use some preferences. So confirm, okay, we talked about a lot of things today. Is there anything that you don't want me to share? And lots of times there is. Sometimes it's like, you share it all. And sometimes I'll ask them, if I could send a message to your mom and dad, what would that be? And I had one kid who said, tell them they have ruined my childhood. I think that's pretty harsh, but I'll tell them that. Confirm the views and preferences, what you got. Just make sure I got that right. This is what I'm hearing. This is what your thoughts are. And is there any homework? Are there things you want them to think about between now and your next meeting? I know with my adult clients, I always give them homework, things I want them to do. Kids do, some things to think about. Anything else you want me to tell the judge? Is there anything mom and dad wanted? That's a really good question. Is there anything that mom and dad really wanted you to tell me today? So that will help you with, have they been coached? Have they been told, you've got to make sure you say this, you've got to make sure you tell that, or anything else. Sometimes I'll do this at the beginning, sometimes I'll do it at the end. Close the interview, de-stress the kid, go back to doing something fun. Because we talked about some pretty heavy stuff here. Go back to, return to a very friendly, generic banter, put toys away, I play clean up, because otherwise I'm on the floor cleaning up the toys, sort of thing. Then talk about what's your plans. That's an interesting question. What are you going to do after this? Oh, we're going for ice cream, or we're going to go buy this. Interesting, you to share this information, yet you're getting this reward to do. Sometimes that can be a real telltale for you as well. Older kids, tell them when you're going to circle back. Young kids, you may not necessarily know when you're going to circle back with them. Older kids, like, we're going to talk after you go to court and I'll explain to you what has happened, sort of thing. And don't make promises that you can't keep. Don't say, I'm going to get you this and you're not going to have to go here. Again, you're not the decision maker, and make sure they know you're not the decision maker. You're not the one who's making the decision, you're providing some input. Next appointment, again, don't meet with them. I had one young lawyer who was on our panel who said, I have to meet with my kid every week. I'm like, why? You have X number of hours on a file, number one. You don't meet every time you're meeting, you're bringing things up. Have a purpose for why you meet with them. I really try to rotate who brings the child to the appointment, as I said earlier. And that gives a sense of balance that you're hearing from the child with mom and with dad. And then again, you see the consistency in their views and preferences. Are they totally influenced by who's outside the door as to what they have to say? Sometimes I don't do that. Like if there's a child who's not seen a parent for years, I'm probably not going to do that. They don't even know this person, sort of thing. Leave time between the appointments for the kids to sort of think about what you talked about. So you have new things. Your first meeting with the child is probably going to be the most extensive meeting that you're going to have because you're really gathering lots of information. And if the child has a counselor that's also working, it's a good idea to build a rapport with that counselor so you're not sort of seeing each other at the exact same times and you're not doubling up on things. And if they're in Alberta and we're going through a PN7 process, if I'm getting a voice of the child report or there's another type of assessment being done, I'll sort of back off a bit so that we're not all seeing the child at the same time. Capacity, that's a big one. Determine, does your client have capacity to give instruction? So Bala and Beerbaum, I think Rachel Beerbaum and Nick Bala, their position is there should be a presumption of capacity where a child is expressly clear and consistent preferences. There should be a presumption of instructional advocacy, but you must ensure all significant evidence is even before the court, even if it's contrary to views and preferences. That's their position. Some kids may very well have capacity, but they don't want to provide instructions. And that is okay. Convention says they have a right to participate, but if they choose not to participate, that's okay too. You can just let the court. I met with a child, they prefer not to have a voice in these proceedings, and then you may or may not say, I'll get off the record, or I can be reappointed, or whatever sort of thing. They have to be wanting to participate, and they have to be willing to participate. Some kids will tell you things they just don't want you to share. There could be all kinds of reasons why they don't want, but they just don't want you to share. And you have to, if they've got capacity, respect that. And that becomes really difficult when you're trying to advocate, but you can't share some. So often what I will do is work with the child and say, you know what, if I could share this, then this may help with it. So might help with that. Some signs of no capacity, frequent changes in mind. If every time you see the child, they've got a totally different version of events and a totally different version of their views and preferences, or their instructions are really confusing and inconsistent, or if there's actual risk of harm in the desired plan. So it's affected by younger children, less likely to have capacity. I'm not saying they couldn't be, but less likely. You're going to be looking for signs of manipulation, alienation. There's a really good case, which I didn't print off, but the case itself is not great, but there's a really good appendix at the back of it that has all kinds of indicia of alienation, which are really good to have that, not like a checklist, but just some of the things that you want to be looking at. Again, alignment, is this child totally aligned with one parent? Again, we're not going to get into alienation at 10 today because that's not my expertise in any way, shape, or form. But you're not going to be diagnosing, but there's various, there could be alienation, there could be affinity, there could be estrangement, really good reasons why they don't want to have contact with a parent, because you'll get into the resist, refuse dynamics. Stages of development, disability. Sometimes you'll have kids who have cognitive issues who may not have capacity to be able to provide instructions. And sometimes neurodiverse children will have a really hard time providing instructions. The test of capacity is, do they have an appreciation of the consequences of their preferences? They can tell you what their preferences are, but do they have an appreciation of those consequences? I never want to see my dad again. What's behind that? Do you appreciate this, this, and this? Or like, mom, I don't want to see my mom again. Do they have an understanding of the consequences of their preferences if they weren't to see a person or not? Is there logical reasoning for the preference? What is it? Why this child has this view and this preference? Get to that. What's behind that? But this is the views and preferences. Tell me a bit more about that. Tell me why. Does this child understand their needs and interests? Sometimes you need to talk to others. Sometimes if you're not sure if this child has capacity or not, and you're working with a counselor, sometimes you want to converse with the counselor to have a discussion as to whether or not you think there's capacity here. Review report cards. That's one of the things I often get. If there's any academic issues, I ask for report cards. I ask for copies of IPPs, which are individual education plans, whether or not there may be psych diagnosis. Sometimes there can be psychoeducational assessments that are done. All that can help you make decisions on capacity. There's a bunch for time purposes. there's just a bunch of things here on when you can't meet in person, the virtual meetings, some things there. That will be some expectations, have a backup plan, make sure you've got privacy. That's the big one for me. And there may be things that you're going to talk about that are going to be really traumatizing or really difficult for a child. You want to have a safety plan in case it triggers. If the child's in your office, you could do some things about it, but if you're 100 miles away or 200 miles away, you want to have some sort of safety plan in place. Again, when you're setting up for video, this is kind of some slides during COVID. Like I think we're all so used to doing video things now, but don't be too casual. Don't be in your bedroom with the bed there and that sort of thing. You are still a lawyer. Have the camera set so you can see if there's anybody else in the room. Make sure you have privacy. Get the child to show you the room. That's the trick that I often do. Ask questions by video is easy. Getting the answers is harder. It's harder to get the attention of somebody who you're not in the room. Bill report is difficult, and that's part of the reason why I don't love doing them, but not impossible. And I've been told I have to grow up and realize that this is how it may happen in the future. Use the fact that they're in a comfortable surrounding to make them more comfortable. Get them to show you their toys or home, that sort of thing. That may help them actually open up to you and build that rapport. Do a risk analysis. Did this work? Did this not? Were there issues we were talking about that maybe this child shouldn't be alone afterwards? Be alert for parental influence. Is it such that there's the doors open, they're outside or in the living room where everybody can hear everything? And I usually ask questions of kids too, like, where are you? Particularly when there's long distances, where are you? Who's around? Where's everybody? Sort of thing. So you kind of get a sense. And when somebody's using a background, that can sometimes be a telltale that there's other people around. And how did the child handle the meeting? Did the parents will report to you if there's concerns afterwards, like that didn't work or this didn't work. Now we're going to do role play. So I'm going to go get our young students who are going to come in. If you want to get up and just walk around for 2 seconds.